Good morning, good evening, everybody. Welcome to USIBC's webinar around the new fantasy sports regulations. We'll take the next minute or so and get everybody situated. We will ask folks to put yourselves on mute and keep the video off to maintain bandwidth. And we will have an opportunity later on for some questions and answers. Or if you want to pop on screen and share your question in person, we're very welcome to that. I think most people by now are familiar with some of the functionality. You could raise your hand as well. I do want to note that we are recording this meeting and we'll make it available publicly afterwards. We are going to give people about 30 seconds to get situated before we start, so please grab a cup of coffee and hang on as we get ready to go. Wonderful. Well, thanks again for everybody joining today's webinar on online fantasy sports platforms in India. I think as everybody knows, there is some new regulations afoot on this area, and we're really pleased to have Abhishek Malhotra from the TMT law firm, who is really embedded in a lot of these issues. The way we're going to structure this today is we're going to have Abhishek share some of his insights about the regulation, and then we'll have some question and answers. And then at the very tail end, we could also talk a little bit about some USIBC activities. Once again, some nuts and bolts. We are recording this session and we'll make it publicly available. If you could leave yourself on mute during the conversation until you would like to ask a question, please do. And also the same goes with video in order to save bandwidth. So with that, I'm going to hand it over to Aditya Vashita from the USIBC team in New Delhi to talk a little bit about our media and entertainment programs and plans for the year. With that, Aditya, the microphone and video is yours, sir.
Thank you, Jay, and thank you, everybody. Good morning, good evening, and good afternoon to all who've joined us today for this really interesting webinar session on the online fantasy sports regulation platforms in the country. This comes in light after a regulation, a framework was put in place by NITI Aayog, the think tank for the government of India, and USIBC has already put in their submission in terms of inputs that we've received from most of our members that are working in this arena. I think the past year, the year that has gone by and the year that we are in is going to be really exciting for the overall media and entertainment sector. I think it has seen some great ups and downs across, and one emerging area that we've seen is actually the esports arena. We've seen a great interest in terms of local content creation, huge amount of technology being used and adopted, global best practices that we've seen being put together. So I think it's really important for us to actually understand whether where we stand.
5, 6, 9, 4. Dopo il segnale acustico, registra il tuo messaggio.
I request everyone to please put them on themselves on mute. It'll be easy for us. Thank you. So yes, I think the year has been really exciting, and we of course have Abhishek Malhotra, the partner for TMT Law Practices, founding partner for TMT Law Practices, to take us through that framework that we've put together, and also to understand the landscapes of this new emerging sector in the media and entertainment industry. For USIBC as well, we are really interested to speed up our work for media and entertainment. We started with our media and entertainment webinar series last year, where we discussed on content creation, regulation, and production, and also discussed certain new emerging technologies that can be put together. In this year, we are going to continue that effort with a new arena that we're looking at in esports, and also understand from all of you how we want to take this forward. USIBC has also got into a strategic partnership with the Department of Commerce and the International Trade Association, and we have Andrea De Silva as well joining us from ITA. We are very excited about this partnership, and we look forward to building that relationship forward to strengthen the US-India strategic relationship. With that, I'd like to give away the mic to Abhishek Malhotra to take us away. Thank you.
Salutations to all. Good morning, good evening, good afternoon, as the case may be. And thank you so very much for having me over USIBC to participate in and share my views on this extremely interesting and emerging area of, I'd like to call it entertainment in the Indian industry. I'd like to share a brief presentation and speak along with it, just so that everyone can be on the same page as to what exactly it is that we're trying to bring forth.
Confirming we can see your screen, Abhishek.
Perfect. Thanks, Jay. So just to begin with, what is exactly the existing framework for the regulation of fantasy sports platforms in the country? And just taking a step back, we are talking about the latest initiative of the NITI Aayog, which is the highest policy-making body of the country, which is looking into the possibility of implementing a nationwide and possibly self-regulatory code to be put in place so that the growth of this entire regime can be furthered. Why is it that there was a need felt for such a self-regulatory framework to be put in place? And I do want to emphasize that there is some importance to the fact that this is a nationwide attempt to do so. I will shortly explain why that is relevant. To begin with, the legality of fantasy sports in India is dependent primarily on the debate of whether or not the game qualifies as a game of skill or a game of chance. Through the through the 1950s and up to very recently, I would say 2018, 2019, and in fact, it's the latest judgment even of last year, where the courts have always grappled with this issue as to, and the basis being that gambling for money is not permissible. So if there is a game that qualifies, that it brings out some element of skill for the players, and it is on the basis of that skill that they are likely to be able to earn money, then that's permissible. So whether it is a game of rummy, or it is a game of poker, or it is fantasy sports, the courts have always first addressed the question as to whether this is a game of skill or a game of chance. And the manner in which it has, or courts have come to the conclusion to allow certain games to go through and be permissible is where there is a greater element or a preponderance of the degree of skill in playing that game versus the preponderance of playing the game of chance. So the second point, that is, judicial precedents have always favored games of skill. The games involving considerable and substantial degree of skill, and that's pretty much defined as mathematically more than 50%, will typically fall outside the scope of gambling laws and hence are legal in India. I must also inform you that the one statute which was enacted at the national level and which has its offshoots in the various states of India is a British era Public Gambling Act that has been taken forward, and it's variations of that have been implemented across each state. Now, why did I say that this particular exercise by the NITI Aayog assumes importance? Because it says nationwide. The reason for that is that gambling is a state subject. So there are states that may allow it, and there are most states where gambling is prohibited. There are certain states which allow nuances of that. For example, the northeastern state of Sikkim, it's a very small state, but it does permit gambling or gambling houses in having physical premises and being set up in the state of Sikkim. If you are to engage in online gambling, they specify that the physical location where the server is situated should be in Sikkim. Certain other states, such as Nagaland, again in the Northeast, provide for a licensing mechanism for you to be able to offer gambling. Now, online gaming is a feature that, of course, has a lot to do not only with the aspect of the digital growth in digital commerce, and of course the ubiquity of the internet, but it has certain issues with regard to interstate availability of that particular game across state lines. And it is of such availability across state lines that often creates possible issues which have unfortunately not all been resolved, or sometimes been resolved in favor of the government, in favor of their argument that this amounts to a breach of the state law and therefore it is actionable. And actionable how? Even in most cases, it is actionable by way of criminal action. So you could possibly be put behind bars and or of course have to pay penalty. So the draft guiding principles that the NITI Aayog has circulated seek to regulate fantasy sport platforms on a national level. Now, fantasy sport has been chosen as the first step towards harmonizing the disparate means of interpreting game of skill versus game of chance, the disparate stands taken by the different states and the different high courts with regard to this. And it is perhaps in my mind a great step forward, because according to me, fantasy sports is a fair bit away from the concept definitely of gambling, and also from the concept of this entire debate of game of skill versus game of chance. What are you doing in a fantasy sport event? You, and I'm transposing myself to be a player of that game. I, as a player of that game, am attracted to that particular game, not because merely the aspect of being able to win money. In most cases, the amounts involved are not substantial enough to attract people for the lure of money. It is an engagement tool. It is a fan engagement tool. I am a fan of certain players who play the game of cricket in India. I wish to be able to create a team of players from India and overseas, so that I try and figure out whether a particular game which is likely to be played on a particular day will possibly have my selected team members playing in real life and performing there. I bring in the elements of my skill in terms of my knowledge of the game as to how the batsman or the bowler or the fielder or the wicketkeeper has performed over a period of time. What are their statistics of the past 12 months or even 3 months? What is it that is likely to play in terms of the decision of the game, in terms of who wins the toss and therefore bats or bowls first? What is the condition of the pitch? Will it favor fast bowlers? Will it favor spinners? Will it favor batsmen of a particular type of skill? Will it favor any other aspect of the game? What is the possibility that there could be rain or moisture in the air which could help certain types of bowlers? What is the possibility that, since it is a game which is being played not through the day only but also at night, at night, there could be in certain places what we call as a dew factor. There is dew that collects on the ground, and that could impact the movement with which the ball moves. So there are various aspects that evaluation of the team that I make. So it is a fan engagement tool. It is entertainment for me. And that's the reason why I get into it, which is why it's a good attempt, first attempt by NITI Aayog, to make a distinction between fantasy sport platforms and, let's say, other gaming platforms, to try and create a self-regulatory mechanism at the national level. Now, what are these guiding principles for the uniform national level regulation? These are principle-based guidelines that are agreed and issued, which must be recognized by relevant national and state level institutions and organizations. And a single self-regulatory organization is set up for the fantasy sport industry, which should be recognized by the government. Now, this, as I said, is a proposal that has come from the highest policy making body, which basically means there is already some amount of input, some amount of studies, some amount of research that has gone in, and that's what has propelled the industry, the policy making body to make these suggestions. In all probability, the manner in which it is framed and the guiding principles are set out should see the light of day, of course, subject to any further challenge that may be brought about. Now, the single purpose fantasy sport industry body, as per this particular document, should have membership of the operators of fantasy sports platforms who in the aggregate have as their registered users at least 66% of registered fantasy sports users in India. One of the comments that we had given to this particular recommendation was, to begin with, let's not limit it to a particular number. Let's not be exclusive and try and integrate as many as possible. The possible retort to this is, if any self-regulatory body has to be successful in retaining its self-regulatory status, then it must have a sizable number of users in the country. As per the last reports, as of December 2019, there are about 90 million users of fantasy sports in India, and I'm more than 100% sure that in this pandemic year, more and more people have switched to online gaming and fantasy sports in specific, thereby increasing that number to a much larger one, possibly 120 million or so, which is about 10% of the population. There should be the possibility of setting up an independent oversight board, and this board should be responsible for the implementation of the uniform guidelines and the principles to ensure that such platforms continue their adherence and compliance with the guiding principles. The whole purpose of having a self-regulatory body in place is that its success is measured by the amount of control it has over its members' actions, and in the event that there are disputes or there are issues that arise, then those should be addressed by an oversight body, or let's say an appellate mechanism that is consisted within the network of the self-regulatory mechanism, and 90 to 95% of the disputes should be resolved at that stage itself and not be pushed to courts. The platforms that are members of the self-regulatory organization should enjoy the benefit of the safe harbor exemption, of course subject to their adherence with the norms and procedures laid down. Why is this relevant? Today, when you're looking at the ease of doing business, when you're looking at attracting investments into this particular sector, one of the risks that you possibly will look at is, of course, the legal position. What is the statistic with regard to the number of cases or number of companies that have been taken to courts in this particular realm of business? And where they have been taken to court, what are the impacts in terms of whether it is purely a civil proceedings? Is it a criminal proceeding? Is it somewhere where you have to pay penalty? If so, to what extent? Are there issues of being arrested, etc.? Those are genuine practical concerns and questions that are asked of a company that is engaged in such fantasy online gaming activity, as when investors are looking to make investments. Now, if you are to provide through this adherence to the self-regulatory mechanism at the national level, the benefit of a safe harbor, then you're automatically saying that, look, I know what the risks are. If I adhere to this book, to this rule book, which is prescribed by the self-regulatory mechanism, I'm okay. I could possibly be pulled into court, but I have a great defense. There is a safe harbor exemption that I enjoy. I only need to show that there is adherence to the norms and procedures that have been laid down. I can't be pulled by state A or state C or state Z into a court of law to say that I'm violating their particular state statute, or I can't be called by a police officer in some town of another state, despite where I'm not operating, to be answerable to as to why my game is made available in that particular jurisdiction. So this is a huge positive from the point of view of investors looking to come into this industry, and there have been a reasonable number of more than, of course, more queries than actual translation into business. But because we advise a lot of startups and other companies that are also industry leaders in this area, we constantly are asked for our opinion, not only on that divide between game of skill, game of chance, but also with regard to these real and practical difficulties and how best to overcome them. I think this is a great step for us to be able to turn around and say, look, we have this great document. It's a guidance document. It's fairly simple to follow. There is a self-regulatory mechanism. There is industry players who will come together and formulate such mechanism. They will take into consideration the interest of the consumers as well as the interest of their members. So I think it's a great way forward. The self-regulatory organization should establish an independent grievance redressal mechanism to handle the consumer or user complaints against the specific platforms, as well as any disputes that arise between or relating to the platforms. The important part is there has to be a two-tier structure. In most self-regulatory platforms or organizations, there typically is a two-tier structure to resolve such disputes. The first level of resolution of dispute will always be available with the specific platform. So there is a company which is operating a platform where online and fantasy gaming is ongoing. If a consumer has a complaint, there'll have to be a mechanism for that consumer to report that complaint and to seek redressal of that grievance by the entity, the platform itself. If the platform is unable to resolve that dispute, or if the consumer is unhappy with that resolution, the consumer should have a mechanism to appeal to that higher level, which is not within the specific platform itself, but goes on to the main organization. And the main organization should consist of industry players, of course. And oftentimes in India, if you do have a retired judge of a high court or a Supreme Court sitting as the chairperson of such a grievance redressal cell or an appellate mechanism, it adds tremendous weight to the orders passed by such tribunals. And also, in the event that you take this in, the consumer is still unhappy and they want to take this to court. Oftentimes, if there is a well-reasoned order that is passed by the appellate mechanism within the self-regulatory environment, courts are very, they reverse it very seldom. They will look at it. They will see that there is a judge possibly who has that experience, who has retired as a High Court judge or a Supreme Court judge, and has therefore been able to give adequate reasons in support of their order, one way or the other, and therefore there is very less likelihood that a court of law will interfere with that. It's only in egregious cases that interference may be warranted. Some self-regulatory mechanisms also provide for errant behavior. Not only could you potentially lose your safe harbor exemption, but there could also be penalty in the form of monetary penalty, and no one likes to pay that money, especially because a lot of these companies in this area currently at least are startups. So therefore, there has to be that trust that is built up within the mechanism itself for the consumers and for courts of law to both be adopting a hands-off approach to let the self-regulatory mechanism play itself out and continue to address those grievances. The safe harbor protection to provide for all absolute parameters, and it will define and determine what a fantasy sports game format is, and what of those fall within the arena of game of skill. So there the courts of law, and specifically the matter that I've referred to in my last point on this slide, it is the Federation of Indian Fantasy Sports as an entity has been recognized by the Rajasthan High Court in the matter of Ravindra Singh Chaudhary versus Union of India. And in this particular matter, again dealing with specifically with fantasy sports, the court went into an analysis of what exactly are the ingredients of what would constitute a fantasy sport, and went about setting certain guidelines to be able to, in my view, help future such organizations that are setting up at the self-regulatory level to be able to delineate that these are the parameters that will define or determine what a fantasy sport is and what qualifies as a game of skill or a game of chance. So I think with these judgments, with the self-regulatory outlook that is being looked at by the NITI Aayog, the time really is ripe for more and more investment to come into this particular area of entertainment. And I would reiterate that it is one, and certainly, to my mind, a great way of engaging with fans. Now, what is the potential of these guiding principles? First of all, it aligns the digital gaming laws with the applicable information technology laws and the gaming aspects in the physical domain, in the non-online domain. It removes the certainty in terms of compliance requirements and, of course, reduces the cost of compliance. So if you know what exactly it is that you need to comply with to qualify as a fantasy sport, if you know broadly what are the terms and conditions of how you will cross that particular divide of game of skill versus game of chance, you know what you need to comply with. So it reduces the cost of compliances. It brings in uniformity across applicability of the principles across state borders and increases business outreach. Consumers to benefit from the fan engagement that is allowed and also treat this as a source of entertainment. And of course, it aids in the popularity of games and sports alike, facilitating ancillary sports entertainment industry. Now, today, one of the biggest source of fantasy gaming is cricket. But increasingly, despite the fact that we are still continue to be cricket hungry, increasingly the availability of information and the availability of being able to connect with sports of different types of sports persons across an entire range of genre of games and sports not only engages customers in terms of entertainment and a possibility of making money, but very importantly, fan engagement. And that, I think, spurs not only a lot of investment, it spurs the development of sports in general, and also the entire industry of not just gaming laws, not just gaming, but also sports overall. And I think that's a huge step forward, and the potential to work on that, to develop that, and to exploit that is tremendous. And to my mind, these guiding principles, the facilitation that the NITI Aayog is seeking to bring with this is the only aspect that can possibly help achieve it. Thank you so much for being a patient audience, and great opportunity here. Thanks a lot to USIBC.
Well, thank you very much, Abhishek. If you could turn your screen off from sharing mode, that would be great. This is the opportunity for folks to sort of ask questions. Either raise your hand or drop them in the chat box and we can call on you. As I guess the moderator, I can ask two general questions. One, where do we go from here? NITI Aayog had an open consultation. People put in comments. Presumably they'll finalize some report. If you could lay out kind of where the NITI Aayog process goes from here. The second question that I have for you has to do with the self-regulatory models. It almost feels like it's not a mandatory membership, but the cost benefit of it is going to almost make it mandatory, namely safe harbor from a legal point of view. What makes this market a little different where that self-regulatory model can be more effective or even necessary versus others? And sort of structurally, what happens if there's two associations or two bodies that kind of meet that threshold, or neither body meets the threshold because the industry is fairly distributed in how it's thinking? Has those sorts of contingencies been thought through as you've been working with NITI Aayog?
Okay, so great questions, Jay, and I'll answer the second one first. I think it is perhaps to ensure that safe harbor exemption that is being given here reaches out to the correct audience and the appropriate self-regulatory organization that can call itself that. That's the reason why they imposed the 66% threshold, 2/3 of all users. The question is, in the absence of a recognized mechanism to really measure, how you can classify the users, what the audience of that users is there an independent third-party mechanism of determining, in an objective manner, that this is really the organization that represents the interests of a majority or 2/3 majority of the users? That's where I think the challenge is going to be. And till such time that we actually see this play out, I don't think that the possible consequences of more than one organization claiming to have a majority of membership, I don't think that's been thought about right now. Comments, I know, have been put to apprise the NITI Aayog of this practical issue that could arise. And I think once the final report comes out is when we're likely to see whether this has really impacted that. If not, because it is a policy document and because these are guiding principles, we do not need to go back to the drawing board as in the case, or seek political support as in the case of Parliament, or even executive, rule-making power, which has to be placed before Parliament. Here, this is a question of policy. Possibly the gaps can be plugged quicker once they are identified. Point number one, just to segue into whatever I've just been saying, the next steps really are, the last date for receiving these comments was the 18th of January. So we're only 2 or 3 days into it. I would think that the NITI Aayog would evaluate those comments at least for about a month. In the event that there is any further dialogue that is required, further debate that's required, sometimes the NITI Aayog also calls for, personal meetings where people can put up their views. So once that is exhausted, I think we should see the final guiding document sometime in March.
Thank you. I'm still looking for questions from the participants, but I'll toss another one your way. With these national guidelines, would they eliminate other regulations around consumer protection or competition or privacy, or are these, the self-regulatory mechanism would be fairly narrow in terms of elements of online fantasy sports?
I think what is being planned in the first step really is to restrict itself to online fantasy sports and the platforms that offer this. So I don't think that there is likelihood of complete substitution of the legal regime in terms of consumer protection and any other aspects that touch upon it. Even in the other self-regulatory spaces, in the event that there is, it's only those gray areas where there is really no clear answer provided by the law that you can take recourse to the self-regulatory mechanism and or consciously choose to not exercise your contractual or other rights and then try in seeking an expeditious disposal of your query or your issue at the self-regulatory mechanism level itself, rather than choosing to go to court. But the option of going to court, even in such situations, if a statutory right, contractual right, and or any penal provisions has been breached by the relevant platform, that continues to remain as is. But the reason why I think that this is a great first step is because the NITI Aayog has chosen the least controversial part of the online games debate, which is the fantasy sports. and the one where a lot of traction has really gained momentum to set the ball rolling. And that's the reason why I think it's a great first step.
Great. We're starting to have some questions from our participants. So I think Abhishek Lahiri is sort of following up on my question in terms of safe harbor. Would, in this narrow segment, the self-regulatory mechanism, what would, if there were some sort of national legislation or amendments around the IT Act on safe harbor, wouldn't the national act supersede this if there's differences, or would the self-regulatory actually carve out protections that may not be in sort of other national legislation? If I frame that question right.
No, I got the drift, Jay. So if I understood the question correctly, is in the event that there is because we already have the safe harbor provision for intermediaries under the Information Technology Act, which is, the IT Act itself is being reviewed, but at this juncture we do have that safe harbor there. We also have a safe harbor under the Copyright Act under Section 52(1)(c). So what you're basically asking is whether this is going to be in addition to those, or if there is a conflict, then how does that get resolved, right? Now, my answer to that is that the online fantasy sports platforms may not qualify as intermediaries. It is possibly because either they are offering some of these fantasy sports which are their own creations, or they stand to benefit directly from the offering of such games on their platforms. So stricto sensu, they may not be qualifying as intermediaries. Nevertheless, despite the fact that they may not qualify as intermediaries, these guiding principles and adherence to those will provide them that cover of protection, the safe harbor exemption. That is completely independent of the safe harbor that is provided for under the legislation that I mentioned to you. But to avail of those benefits, you have to first demonstrate that you're an intermediary.
Great, thank you. So if I understand what you're saying in general is the self-regulatory body starts to give a number of, I guess, rights to companies as long as you meet the guidelines around things like safe harbor, around consumer affairs, and so forth. But there's the possibility that other national laws would supersede it if and when those laws are changed or come into place.
Absolutely. So
okay.
That goes without saying. In the event that there is so I'll put it a slightly different way. Despite the fact that there could potentially be liability attracted to such platforms for offering fantasy sports under specific state laws, these guiding principles and adherence to those, by way of policy, will seek to trump national laws. I'm sorry for using that word now, but nevertheless, and that's the safe harbor exemption that provides. So it's a defense. I would not call it a right, so as to speak. It is more going to be a cover or a defense to an allegation that you are indulging in something which is intervenes with or infringes upon a state law. But the laws of the country overall will remain untouched by this provision. And I'm maybe there's a possibility that once this policy is notified, it could be subjected to a challenge by a public interest litigation for seeking to, quote unquote, furthering gambling online. And in that particular petition, if the court really says no, we are giving our stamp of approval to this policy, then that's the best.
Great, thank you. We have a couple of questions, and I'm going to clump them together for you. The first one has to do with how the guidelines, the NITI guidelines, will then be used. Will they be guidelines? Would they recommend there's a law? And then how might states either incorporate either regulations or some national law? Would there need to be some state level follow-up activity to accept them or legalize or so on?
So since NITI Aayog is a policy making body, it will lay down a particular set of guidelines or policies. So NITI Aayog, sometime in March of last year, came out with the telemedicine practice guidelines. Ultimately, those guidelines had to be translated into either a legislation or rule, and in that case, it was translated into one of the provisions of the existing Code of Medical Ethics, practicing regulations, which has the force of law. So whatever regulation comes, whatever policy announcement comes out from the NITI Aayog will necessarily have to get translated into a document or let's say something which has the force of law. It could be in the form of a legislation, it could be in the form of rules or guidelines, but that will have to have the backing of law and not just be left in the realm of policy.
At the state level or the national level or both?
The hope is that it shall be national level, and the implementation of this could be a carve out to the specific power of the state under gambling, so that it can be brought under the head of entertainment, and that too in specifically giving the power to the center to enact a law on that. I am anticipating that this is bound to create some amount of conflict and court actions in challenging that, specifically in the event that the allegation is that it takes away the state powers to regulate gambling. But if that policy document is well thought out and well supported, I would think that it should be able to see the light of day, especially given that in the last couple of years, the courts have always come out in support of fantasy gaming as not being gambling.
Great. So what's the cost or revenue implications here? Is there a financial element? Do we think that ultimately the governments, either federal, state, might, tax it? How, in terms of the self-regulatory mechanism, how might they fund themselves? And sort of the ancillary question there is, if there is sort of this revenue piece, bigger companies may be better able to utilize or participate in the self-regulatory model at the detriment of smaller and startups that may not be able to influence that.
So I think in the event that the requirement of the two-thirds majority, two-thirds of all users is stuck with or increased, then I don't think that the bigger companies would be in a position to exercise the kind of muscle power that we are anticipating, because then it's one big company versus 10 smaller ones, and it's a game of numbers. So and given the fact that there is always a possibility for the bigger numbers, the smaller parties will typically be in bigger numbers, to walk away and set up their own self-regulatory mechanism, I think that will probably act as a fetter for the exercise of the muscle power within the entity itself. In terms of the revenue model as such, I think we have seen in the broadcasting sector and also in it's already being mooted to and it's a document that's already been executed. It's another thing that whether we'll really see the light of day in relation to the OTT platforms. But I think when it is a question of setting up an objective and a platform which will get the trust or needs to get the trust of its participants as well as the consumers, there is possibly already inbuilt into it the necessary principles by which the guidance can take place for the individual members of such an organization. So while things could go wrong, and of course there is always likely to be issues that needed to be resolved, but my thought process in this regard is, today the number of companies are not as much, and today there is greater amount of benefit in staying together than creating a fractured organization. That will propel people to actually come together and set down a set of guiding principles to guide them.
Great. I think I know the answer to this one, but R.S. Rao asked about if models that use fee to pay, would they be covered in this?
Sorry, fee to pay.
fee to play.
Fee to play, yes. So then, of course, because there is the whole point of having real money gaming getting associated with fantasy sports is that there has to be a fee that is to be deposited for membership to such platforms. And then specifically, if you're selecting a team, you will be given a budget. There's necessarily some amount of money involved. So definitely, the answer to that is yes.
Great.
As a few raise of hands, so why don't we take a few raised hands and then we can come back to the questions in the chat box. So maybe we can go with Sesh first and then Sean.
Yeah, thanks. Hi, this is Sesh. I think you've kind of answered the question that I had on revenue. The next question I have is in terms of technology. Are there is it fair to say that NITI Aayog has a solid understanding of the underlying technology of these platforms and their security and capabilities? And how mature is that in India?
Okay, so I think to my mind, the focus of these guiding principles did not have much to do with the underlying technology. The focus of this was to harmonize at a national level some sort of guiding principles that would regulate the activity itself of such platforms. Perhaps when this industry in itself goes through that process of greater amount of maturity is when we are perhaps likely to see those questions coming up. But I think not necessarily through this particular paper, but otherwise in terms of the robustness of the infrastructure or the security aspects thereof, those are things which, to my mind, the individual organization that is offering such platforms itself needs to be compliant with in order to have longevity, because it's only when it puts robust systems in place and has a proper mechanism for people to not be subjected to any issues on cheating or otherwise, that it can really continue to prosper. So I think those have not been, to answer your question, those have not necessarily been considered by NITI Aayog in this paper. Possibly it could be food for thought for some further developments.
Thank you. Sean from Dolby.
Great, thank you. This has been very helpful. I wonder if it's possible to obtain the slides that were used, if those haven't already been distributed. And then I'll ask my question.
Yeah, I mean, from my point of view, it's perfectly all right.
Great, thank you. You said that the final principles, once promulgated, would have force of law. And I'm trying to understand better, what is the source of authority, statutory or otherwise, that gives this department the ability to issue rules that would supersede or preempt or extinguish state laws and jurisdiction?
Okay, so my answer actually is that when I was and just part of my answer to one of the questions raised by Jay, that the NITI Aayog only lays down policy. It is the highest policy making body of the country. Those policies, for them to get the force of law, will have to be incorporated in a document such as a legislation or a statutory rule or regulation for them to really have that force of law. So in and of itself, this will only be a guidance document or a policy level document, but it must get translated into a quote unquote legal document for it to have the force of law.
All right, thank you. I'm sorry, I didn't quite appreciate that. One more question for you is, I'm not familiar with the significance of what's involved in becoming a registered user. You said that the threshold of 66% or 2/3 of registered users has to be satisfied for any organization to benefit under the principles as the self-regulatory body and benefit from the safe harbor. Assuming a group or some organization were to meet that threshold, 66%, is it a static or dynamic situation? How would the government assess whether users or subscribers are changing between platforms? An organization that might represent 66% of users over time might become less popular. Another group might have different or more interesting entertainment and see its registered user count increase, in which case the first organization might then fall below the threshold and therefore potentially lose its ability to claim that it is the self-regulating body and its members can avail themselves of the safe harbor. Maybe you could speak a little bit more about, again, the significance of what's involved in becoming a registered user and how easy or not is it to switch between platforms for purposes of having an organization qualify under the safe harbor?
Sure, Sean. I think it's a great question. I tried to address it partly in during the time that I was actually speaking, but let me just build upon that. I did mention that this was one area which is quite ambiguous in terms of its application and practical play out. And you're right. One of the aspects clearly is that it is unidentified as to whether it is dynamic, and it is bound to be dynamic. But and that's the reason why we also did in our responses to this document, because it's still in a draft stage and responses were invited from stakeholders and members of the public. So we did highlight this aspect to the NITI Aayog and specifically ask them to formulate more objective guidelines to be able to have a clearer path for entities that are actually going to be availing of the benefit of the self-regulatory mechanism. You're right that at any given point in time, what is the registered user base of a or a given set of platforms may change, let's say over a 6-month period or a year or so. Now, to my mind, the possible response from the NITI Aayog, which I'm expecting, would be that the pull or the benefit that is accorded by adherence to the self-regulatory code in itself would attract most of the people to such self-regulatory organizations and allow them to become members of these organizations, thereby satisfying at any given point of time the above 66% threshold. Their point, in my view, would, I am not prescribing a 90% or a 75%. Yes, 66% is arbitrary, but to my mind, it lends credence to the fact that it should be more than a simple majority. And at any given point of time, the benefits of associating with such an organization, and the first mover advantage of an organization always helps in continuity. So there's a greater likelihood that the entity that is already set up to begin with will possibly carry that aspect forward and continue to have that greater than 66% user base to enable it to get the benefits under the proposed policy. But you are very right that it is something that still needs to be seen in terms of how it plays out. And because the original guiding document is a policy document, I think the possibility of improving upon it will always be available. But it is a concern.
Thank you very much.
Sure.
Thank you. Any other questions from the participants? I have one or two more if not. Great. One is, does anything in this document discuss anything around IPR, data sharing mechanisms, or anything of that nature as part of a larger discourse around those sorts of issues? And the second thing is, representing, U.S. India business interests. Is there anything in this document that U.S. companies would or should be concerned about in terms of how a foreign company might be represented in this environment, or oppositely, it holds, provides a lot of coverage for them?
So there's, in terms of the other issues that you identified on IP and data protection, there's nothing specific in the document. And I just think that very specific and dedicated and directed view and objective to be achieved was only to get a national level document in place, B, a guiding policy, and C, a self-regulatory mechanism in place. So I think consciously they have chosen to stay away from other aspects that could involve a larger debate and perhaps put it as one of the points for either the individual companies to assess and determine, and or the self-regulatory organization as and when it does get set up to address from an internal perspective. In terms of specifically for the US companies and entities, the one aspect that I noticed is when the comparison is made in the document with regard to the self-regulatory mechanism and what exactly are the contours of governance and regulation in the aspect of fantasy sports, the only industry and the only country that is looked at for comparison is the US. And that, to my mind, gives an indication of not only the importance of the gaming and the fantasy sports sort of industry in the US vis-a-vis India, but it also gives an showing of intent that the attraction of investments, companies, users, etc., is likely to be with the US in mind. So clearly, that intent is exhibited in this document.
Well, with that, I want to thank you, Abhishek, for your insight here. We are spot on time.
Jay,
So
I
really,
think we have on the raise of hand. Maybe we can take just final raise of hand and then we can go ahead. Sarah Taylor, please.
Oh, yeah, that would be great. If we have time, I was just curious, could you talk a little bit more about how these regulations might apply to foreign companies operating in India versus domestic companies?
So, Sarah, there is, as I was just saying, there is no clear, distinction between the nationality of the company that is being looked at from the purposes of making this these guiding principles applicable. But there's no restriction or limitation with regard to foreign investment in the online gaming, the digital gaming space. So what is applicable to the companies? I mean, of course, the company that is running it will have to be registered in India, and from that perspective, it's an Indian company. But there is nothing that restricts or creates any impediments for or provides any undue favors for any company coming out of any particular nationality. So that distinction is not made out in this document.
Is that, sorry, just a follow-up. Is that true even for Chinese companies?
So there is, this particular document does not go into the distinction between the nationalities. I think the limitation on foreign investment and specifically with regard to what is the process that is to be followed for foreign investment to be allowed into the country is dealt with under the document that deals with the different types of industries and different types of levels of foreign investment that are permissible. And the issue that had arisen earlier in 2020 with regard to restriction on origination of investment from Chinese companies or neighbors was, of course, in relation to the border dispute that is going on at that point in time. And in India, when you are attracting foreign investment, there are two routes that are prescribed. One route is where you have what's called as the automatic route, where you do not need to take permission from the government department. You straight away put in your application, and that application just shows your intent, and you proceed with the necessary licenses and go ahead and start doing your business if any licenses are required. In the case of those, the companies that, the areas that require prior permission of the government, these are not automatic, but require government permission, there, in addition to the licenses that you require to run the specific business that you're getting into, you first need prior permission from the Foreign Investment Authority for you to be allowed to carry out that investment into India. So it was in relation to the Chinese investments coming in that there was a stipulation put in that each of those investments would be scrutinized by the government department before being allowed to be allowed to invest in India.
Thank you. Any final questions or comments? Great. Well,
Yeah,
with that,
I have a last, a final question, maybe, not related to this, but, as of today, the gaming laws are not clear. So any game which is free to play, right, and is a game of skill, yeah, uh, but has a winning prize associated with it, right, monetary, does that game comes under the purview of online gaming or a fantasy sports or RMG?
So RMG is real money gaming. Wherever you're getting into the aspect of winning a prize money or some money associated with it, there is a possibility of scrutiny to be put, whether it's a game of skill or a game of chance. In the event that there is if you are saying that you do not need to put in any money to play that game, so therefore there is unlikely to be any chance of losing money, and the only aspect that you are concerned with is whether or not you're likely to win a prize. Lesser issues, lesser regulation concerned with such instances, but whether or not it will qualify as fantasy gaming is something which are very specific parameters. Fantasy gaming is always you are quote unquote betting on the capability of a live set of players playing a live game and predicting the outcome of that. So that's the contours of fantasy gaming. That's where it gets distinguished from like a game like Rummy or poker or otherwise.
All right, thank you.
Thanks.
any final questions? Once, twice, sold. Abhishek Malhotra, thank you so much for your expertise here. We really appreciate it. I want to thank our members and other participants. We're really pleased that you were able to join. As Aditya mentioned up front, this is part of a larger initiative that USIBC is looking forward to leaning into during 2021, and we look forward to other opportunities to talk about important media and entertainment issues, policies, and opportunities. With that, we will share with the participants here the slides. We will also share our submission to NITI Aayog, and we always welcome from members and other interested parties to reach out to us with any questions, issues where we might be able to help. With that, I wish everybody a happy new year and please stay safe.
Thank you so much. Thanks a lot, Jay. Thanks, USIBC, and thanks to a great and patient audience.
Thank you.
Thank you. Thank you, everyone, for joining.
Thank you.